The Honorable Todd Staples, you're recognized.
Thank you, Mr. Chairman. Thank you, Senator. It's good to be with you this morning. My name is Todd Staples. I'm president of the Texas Oil and Gas Association, and we're here in support of House Bill 2595. Very simply, House Bill 2595 is a private property owner, real property owner protection bill. When initiative and referendum is used in regard to private property, that process simply does not allow or afford the property owner the constitutional rights that are afforded that individual property owner. We think when issues regarding the limitations on private property are used, it should be done in a deliberative process so that the constitutional rights can be protected. Now, I have friends that have looked at this bill, and their concern that they've raised to me is that cities might unfairly use this new language to limit the acceptance of any INR referendums. But if you read the plain language of the bill, it's very clear it's regarding the limitation of private property usage, and feel very comfortable that you could make that argument where they would not be able to inappropriately use this language. But if you care about the protection of private property rights, if you want to have a deliberative process, then this bill is the bill to be for, and be happy to answer any questions.
All right, any questions for Todd? Thank you for your testimony.
Thank you.
Linda.
Howdy, members.
Senator Hall, if you have a question, this might be Todd Staples might be the one to answer your question if you have a question.
Yes, the question I had, what are some examples of things that took place that precipitated this bill?
Well, obviously, from our perspective, what occurred in Denton when there was an initiative and referendum was used without considering that those rights would have to be paid for to certainly one. But I can tell you in my previous work as Commissioner of Agriculture how limitations on private property use and abuses occur, and how this bill would protect that. For instance, if someone says we don't want horses on private property, you could inappropriately use an initiative and referendum to restrict that use, where if you're going to limit the use of that property, which cities have the right to do and will continue to have the right to do, they have to do it through a deliberative process in order to make it work appropriately.
Okay, thank you.
Thank you.
Okay, thank you. Now, Linda, you're recognized.
Members, my name is Linda Curtis, and I'm here against the bill on behalf of Independent Texans, a general purpose political action committee that I chair, and on behalf of Homeowners Taxpayers Association of San Antonio, Corpus Christi Patriot Tea Party, William Benton, Rosenberg City Councilman Dan Comstock, Republican Party Precinct Chair, Harris County, Sam Houston Tea Party in Huntsville, Communities for Thriving Water Fluoride-Free San Marcos, Fred Blanton, Harris County Republican Precinct Chair, Pastor Aubrey Vaughn, Director of Tri-County Texas Tea Party in Cleveland, Texas, Alvin Tea Party Patriots, and last but not least, Barry Klein of the Houston Property Rights Association. And we are people who have been doing petitions. The gray hair that you see has been spent on the street talking to people all over the state of Texas. And let me tell you, I think what happened with this bill, very honestly, is that we, the people who care deeply about initiative and referendum, we are Democrats and Republicans and Independents and Libertarians and Greens. We were remiss in missing what this bill was actually about in the House. So therefore, we weren't at the committee hearing. I learned about it later. We all thought this was a fracking bill, and fracking had been resolved in HB 40. I'm told that that's what the Lieutenant Governor's office actually thought about it. Now, I have a long history here in the city of Austin. Definitely I am a thorn in the side to the city working with a local developer here. In 1995, we petitioned to stop a $20 million subsidy of a baseball stadium. And it wasn't that we didn't like baseball, I promise you. A lot of us were baseball fans. But what really upset us is they used an emergency provision in the city charter to call this an emergency deal. And so we had a lot of fun talking about the emergency baseball station, socialized baseball in Austin, and it went down 2-1 at the polls. Can you give me one more minute?
No, ma'am. Sorry. You've done good. Good job.
Can you give me 15 seconds?
15 seconds. Sure.
Okay, thank you. Here's what I'd like you to do to really seriously consider working with us in the interim to come back with a petitioner's bill of rights. Petitioners are being thrown out all over the state by cities We are petitioning them. Don't give them any more handle to stop us. Thank you very much.
All right, thank you.
And members, if you'd allow, just to clarify on this, this bill was brought to me and I agreed to hear this bill, but I also looked at what happened in the House, and I want to make sure it's clear that this bill in the House had very little opposition in committee. It wasn't snuck through. They had a hearing on this. It passed out of committee, I believe, in the House. It was brought to the floor of the House. The very little controversy. I think it was 115 votes in favor of it. So this bill had a very, very good airing in the Texas House, but we're the Senate, and we are having an airing in the Senate. So
thank you. I appreciate that.
This
Right.
Yes, sir.
Any other questions? Thank you for your testimony. How about Ed Johnson?
Ed Johnson, I'm with the Harris County Clerk's Office. This bill just came to our attention too. We missed it going through the House. It seems like we focus on election issues since we run elections, and it didn't go through the election committee, unfortunately. We see getting caught here in the middle, being the bad guy at the end of the trail, because we run the elections for the city of Houston and other cities, the other 7 cities, major cities in the Harris County area. And we've already got into this problem when a petition is filed. The petition is usually filed against a city for some measure that they're trying to do to put something on the ballot to be voted on. When the petition is rejected, of course, in Harris County and Houston, that's 50,000 signatures. Well, we have 50,000 people now up in arms taking a lawsuit to try to stop the election, which happens to us quite often. They'll file a lawsuit to halt the election, and then that messes up all of our obligations that we have to do. We see this bill really overreaching. It doesn't define. They added an amendment in the House where it says real property. It says, I think, private and real property. That makes it really broad and gives, in our opinion, the city's great authority to reject petitions, and then we're going to be caught in a lawsuit after the petition is rejected trying to get it resolved, and we're going to miss our federal obligations to get overseas ballots mailed and stuff like this. We would love to see this bill refined to what actually the problem is. If this was a fracking bill, if this is to do with oil, let's put that in there so it's clear, so it can go to a court, that the decision can be made clearly.
All right, any questions?
Clarifying that's the input we're looking for that we missed in the House, and so that is the purpose of having the hearing to air this issue.
Thank you so much.
Thank you for your testimony. Tricia?
Chairman, members, my name is Tricia Davis. I'm the president of Texas Royalty Council. We're in support of HB 2595. We represent thousands of Texas royalty owners throughout the state. Over the past year, landowners and mineral owners learned quite clearly that their property can effectively be condemned by a vote without any action by elected officials responsible for spending their time thoroughly analyzing the impact of such actions. There are over 570,000 mineral owners in Texas, many of them, like my family, active in their communities, serving as volunteers, passing traditions afforded by minerals that provide enough revenue to pay taxes, maintain, and live on land passed through generations. The vast majority of mineral owners are regular working families whose children, grandchildren are able to attend college because of the family royalty income. Other families depend on royalty income to pay for medical expenses, still others to make ends meet or supplement retirement. Mineral owners are part of the proud oil and gas heritage in Texas, a state that recognizes mineral ownership as a constitutional private property right. We elect officials to make decisions about policy for our communities. Local initiatives and referendums are often determined by bumper stickers and yard signs with heavy influence from outside activists who do not know the effects of condemning properties can have on Texas families. As a property rights state, Texas should not allow initiative and referendum to determine use of private property, and we ask that you support HB 2595. Thank you.
Tricia, I appreciate your testimony, and the thought comes to me about some of the big problems California got into by initiative and referendum.
Members, thank you so much for the opportunity. My name is Bill Stevens, and I'm here this afternoon representing the Texas Alliance of Energy Producers. and that's an oil and gas trade association with about 3,400 members across the state. We want to thank you for having a hearing on this bill. We testified on it in the House and felt like it was a good bill, and I think that the votes over there showed that. We all believe in our democracy and the rights of our fellow citizens to speak out, but some issues deserve very careful scrutiny and deliberation beyond what can be accomplished in a petition drive, a public relations campaign, or a push poll. And I would say that taking one's private property rights and or the access to that property deserves careful scrutiny. And we would think that this type of deliberation is provided for in our city councils and our planning and zoning commissions, and that's a more proper venue for such weighty matters as taking one's private property. And just to say lastly that a taking is a taking is a taking, and if you're going to take personal property rights, even if it's the matter of a vote of your fellow citizens and neighbors, that's maybe even more egregious. And it needs to be deliberated, and it needs to be part of the, and we're not diminishing in this bill, not at all diminishing the ability of the ordinance power of the municipality. So we're in favor of the bill. Thanks so much.
Thank you, Bill. Any questions for Bill?
My name is Sheila Hemphill. I'm from Brady, Texas, and I'm here to encourage to vote against Senate Bill 2595. I come at this from a different perspective than what the prior testimony was. As the citizens who have participated in petitions to fight against what is deemed by the community as less than prudent decisions, possibly of the City Council. When he was talking about the use of private property should be preserved, and then when it could possibly be prohibited from economic gain, yes, that's a serious situation that needs to be considered. And right now, the way that district courts have ruled on prior cases is that the petition of the people goes on the ballot. The legality of that petition comes into play in the event that that bill passes, at which time it would go into litigation under a judicial system. The aspect that the deliberation would take place with the city attorney being at that discretion to determine whether or not that petition goes on the ballot, I find a complete conflict of interest, given that in many instances these initiatives are being put forth by the city who have already had an ordinance, or we wouldn't be doing a referendum petition. So you're already in a conflicted situation between the city, aka the city attorney, and the citizenry. A petition simply makes that issue subject to the vote of the people. And about people's personal property, what happens if the use of that individual's personal property impedes my access to my personal property? So when people choose to live in a community, they agree to abide by ordinances, and they agree to be subject to certain limitations. And so there may be instances that your desire of use for that private property is not deemed appropriate by the community that lives there. And the aspect that we as citizens would not have the right to do something about it through referendum petition, I would ask that you preserve our fundamental right for petition.
All right.
Thank you.
Sheila. Any questions for her? Appreciate your testimony. Stephen.
Good afternoon. Thank you, Mr. Chairman, members of the committee. For the record, Stephen Minnick with the Texas Association of Business. You've heard some good testimony, and we are in favor of the bill. You've heard some good comments and testimony in support of the bill. I think you're going to hear more. I'll just make one point. Elected officials in a municipality have a fiduciary responsibility to protect their citizens and to act responsibly. I see this bill in a very limited number of circumstances protecting those elected officials who otherwise will be precluded from acting with their proper fiduciary responsibility and having the decision taken out of their hands by people who aren't elected. And so I think a lot of the examples you heard have to do with ordinances and land use issues that I'm not sure are really what this bill is actually getting at. I think it's focused much more directly on the actual taking of private property and the preclusion of use of that property outside and beyond the normal ordinance-making authority that we're accustomed to. So I'll close here and be glad to answer any questions.
All right. Thank you, Stephen. Any questions? Appreciate you being here. Tom?
I'm Tom Glass. I'm from Houston, Texas, and I oppose HB 2595. I represent today the League of Independent Voters of Texas. Whenever you look at a language or of the statute, the language is important, but who decides what that language means in a particular situation is even more important. We go to great lengths in this state and our system to make sure that judges are unbiased, and we put all sorts of rules around that unbiased. Think about what initiative and referendum in a city is. It's the city has done something that a significant portion of the citizens disagree with, and therefore have not done what they want to, and so an initiative needs to be done, or they've done something the citizens disagree with, and they need to have a referendum to stop it. What this bill does is gives the power to decide whether it makes it onto the ballot to the very people who are being targeted by initiative and referendum. It is an essential evisceration of initiative and referendum because it gives the power to the very people who are being targeted by it to stop it. Somebody mentioned the word plain language of the bill. The language itself is not plain. It is very clumsy. It is very hard to understand what it means. If you read it, it says if the government enactment or repeal would restrict the right of any person to use or access the person's private property that would limit the use of real property for economic gain. Well, is my house, if it goes up in value double over the time I live in it, and I'm worried about that, am I getting economic gain off of that, or is this only for special interest? I'm very worried that the special interests that dominate, or the ideologues that dominate city governments, are going to be able to stop any citizen input, or the one remedy they have against the domination by the special interest of their city. This also creates a cause of action for those who, if it makes it onto the ballot, but it leaves very little for those who don't. So we welcome any questions if you've got more about this.
Any questions for Tom? Are you a lawyer?
I am.
Okay. So if it's confusing to you, think about what it is to us.
Exactly. It's litigation ready to happen. I mean, are we going to be able to stop sports stadiums with initiative? Are we going to be able to stop developments? Yeah.
I didn't make that comment.
All right, thank you.
Thank you for your testimony.
Thank you. I was hoping so.
Senator Hall.
One quick question. I
Yes,
apologize. I had come in the middle of your testimony, so you may have said it.
Okay.
What question I'd asked earlier, how many incidents, various types of incidents, have been occurring out there other than what happened in Denton that would lead to this?
I don't know. I think Denton fracking ban was the instigation of this. HB 40 has handled it. We don't need this to do it. And this is a hammer that destroys initiative and referendum, but to be able to respond to the Denton fracking ban is handled. So why are we destroying initiative referendum with this bill? There's all sorts of things that would be stopped by this. If you want to regulate where adult entertainment's gone, where abortion clinics go, red light cameras, any restriction of business for any proximity to schools or churches, restrictions on property to protect public safety and flooding, restrictions on rail projects, which I was involved in Houston. All of those things would be stopped by this, and in my opinion would violate the Constitution of this statute will violate the Texas Constitution on initiative or referendum. It does the constitutional provision does give limitations to the Texas legislature, but you put so much restrictions and limitations on it that you eviscerate the concept, and no initiative referendum is going to make it to the ballot. You have violated the Constitution with a statute. So this is litigation waiting to happen. Let's kill it now.
I take it you are against the bill?
I am.
Thank you. All right, Tom, thank you. Peggy.
Hello, my name is Peggy Venable. I'm representing Americans for Prosperity in Texas today, and I'm testifying on the bill. We have some concerns that while well-intentioned, we believe that there could be unintended consequences with this legislation. We do support a citizen's right to petition their government, and we believe that House Bill 40 probably covers much of what this bill was initially intended to do. We also have concerns that I truly do not trust cities with the authority to protect our property rights. Let's remember that the Texas Municipal League filed an amicus brief on behalf, in the Kelo decision, on behalf of the City of New London. I do not trust cities and the Texas Municipal League to be able to protect our property rights. Thank you.
Okay, so you're on the bill.
On the bill, yes,
Any
sir.
questions for Peggy? Panel, appreciate y'all's testimony. Did I see Bruce Holtze here? Yeah, there you are. Bruce, come on up. Robin Schneider, come on up. Coleman Hemphill and David Weiberg. Okay, Bruce, take off.
I'm Bruce Holtze from Houston, Texas, and I'm head of Let the People Vote in Houston. I'm also chairman of the board of Compressor Engineering. We do a lot of business with oil and gas industries, 50-year-old business. I've been involved in charter changes in the city of Houston for many years. The latest one that's been passed was a Taxpayer Bill of Rights that limit the growth of government to inflation and population. Our real question is, what's the purpose of HB 2595? Is it to take care of the fracking stuff? If it has been, then we have already got HB 40. It's not very clear what's in this bill, what the purpose is. The effect that I see is that it will give the unelected city secretary the right to deny the signatures on a petition regarding personal property or now real property. That was an amendment to it on the floor at the House. This bill can block Home Rule Cities initiative and referendum. I ask, why is an election bill in the Urban Affairs Committee? Why is an election bill in the Natural Resource Committee? Strange to me.
These are questions we don't ask around here.
Yeah. In my case, in 2001, the city secretary refused to count 35,000 signatures in 2001, didn't get on the ballot in 2001. We had to wait 3 years to go on the ballot in 2004. We received 242,000 signatures. The city then refused to certify the election results. They refused to put it in the city charter. They refused to send a copy to the Secretary of State. We had to go to the First Court of Appeals, get a writ of mandamus from the First Court of Appeals to get those things done. Then Mayor White said, I'm not going to pay any attention to that anyhow. You guys have no standing, and you guys have no jurisdiction. We've been fighting that all the way to the Texas Supreme Court, where they said, at that time, they said that the case isn't right. We're back in court again on an initiative that passed by 200. We had 242,000 people, more than voted for almost everybody in the city of Houston and the county.
Okay, questions for Mr. Holtze? Appreciate your testimony.
Thank you.
All right, Robin.
The right to petition is a fundamental right
Name
of
for the record,
Texans.
please.
Robin Schneider, sorry. Thank you so much, Senator Estes. Robin Schneider, Texas Campaign for the Environment, testifying against House Bill 2595. And it's important that we have Texas-style initiative and referenda. It's at the local level. It's part of the checks and balances on local government, and the courts come into play as a check and balance on the process itself. And because it's such a fundamental right, that's why you have such a diverse group of people opposing this bill. The voters of Texas elect you. They elect our federal folks. They elect our local governments, officials, pass constitutional amendments, charter amendments, state and local bonds. Certainly, they can be trusted to vote on local initiative and referenda. This would put an extreme amount of power in the hands of city staff to keep an otherwise qualified initiative or referenda off the ballot, denying Texans an opportunity for a vote. The criteria to be used by the city staff is whether it will limit the use of real property for economic gain. It's very vague. At the local level, there are so many issues that deal with various property rights and interests. For instance, in Austin, the voters passed a smoke-free ordinance at bars and restaurants. However, the author of the bill on the House floor claimed that this would not affect smoking ordinances. But as we saw with the Austin Initiative, bar and restaurant owners definitely argued that this would affect their ability to make money at their restaurants and bars. Would the city secretary then have the grounds to keep a smoking ordinance off the ballot? On the floor, the author said this is about Denton. As everyone's been saying, we took care of that. The legislature took care of that. The governor has signed the bill. That one's over. This will cripple the initiative and referenda process. If we want to reform the process in some way with a petitioner's Bill of Rights or whatever, let's have that discussion, but let's not do this kind of a hatchet job on it at this late hour in the session.
All right, Robin, thank you for your testimony and questions. Appreciate you being here. Coleman.
Thank you, Mr. Chairman and members of this committee. My name is Coleman Hemphill from Brady, Texas, and I'm here to testify against HB 2595. It's my opinion that HB 2595 threatens our essential God-given First Amendment right. HB 2595 would essentially force municipal attorneys to perform a judicial review of a petition of the people to ascertain if the rights of the person's private property for economic gain is being infringed upon by the petition. But HB 2595 does not provide for any of the procedural or other legal protections for petitioners that accompany true and legitimate judicial review. Texas courts have uniformly condemned local municipal authorities issuing writs of mandamus compelling city councils to perform their ministerial duties and to place petitions of the people on the ballot. In the court case, Taxpayers Association of Harris County versus the City of Houston, it states that the power of initiative and referendum is the exercise by the people of a power reserved to them and not the exercise of a right granted. In Blanchard versus Fulbright, the court held that the city officials do not have the right of judicial review, whether performed by the city attorney or by the council itself. The question of the legality of a petition is invoked once the petition item wins the ballot vote, at which time litigation can be conducted to determine the legality of the proper judicial procedures. Texas courts have long looked skeptically at the efforts by local government bodies to thwart citizen efforts to obtain a vote on important local matters. In Colson versus City Council of Victoria, the court issued an emergency writ of mandamus to compel the city council to allow a petition item to be placed on the ballot for a public vote. The court determined that the act otherwise thwarts the will of the people. I believe that this bill would thwart the will of the people, and next to the ballot, the petition is our most sacred right for recourse against issues that we're able to say no to government-sanctioned programs or to business practices that otherwise, that the consensus of the people vote upon and determine is not in the best interest of their community. And so I ask that we would table this and that this would go away.
All right. Thank you. Any questions for Coleman? Appreciate your testimony. David.
Thank you, Vice Chair, members. David Weiberg from the Texas League of Conservation Voters here to testify against the bill. I'll be very brief. First of all, Senator Frazier has left the room, but I will own up and say guilty as charged. This bill kind of slipped past us in the House. We did kind of catch it late. We were doing some work on it. We did give the bill author in the House an amendment to bracket this bill to mineral rights issues, but that was not accepted by the bill author. I believe, as has been stated, we are here today having this discussion because of the Denton fracking ban. We have settled that issue. HB 40 today is the law of the land in Texas. If we're not here about fracking, then what are we here about? People this year have mentioned issues like trees. They've mentioned issues like bags. We have had legislation in this body filed on those issues. Earlier today, horses were mentioned as a possible reason for this law. I would ask you, please, there's about a week and a half left in this legislative session. Do not pass a bill which would tell your constituents that they could not have an up-down vote on a project with huge environmental, public health, and community impacts in your district, such as a new highway or a new reservoir. If this, again, as Robin stated, if this is an issue that needs to be studied in the interim, so be it, but we feel that this bill is very bad public policy. Thank you.
All right. Hey, David, since Senator Frazier is gone, I'll speak for him. He'd be happy to look at your bracketing language. Not saying whether you'll take it or not, but they're always open Their office is always open to good ideas.
Yes, sir.
What? Anyway, don't laugh at that, please. Okay, thank you, panel. Appreciate it. Cyrus Read, are you here? Mark A. Miller?
You're late. I must have missed something.
Fred Lewis?
Thank you for the record. My name is Cyrus Read, Lone Star Chapter of the Sierra Club, very much against HB 2595. In fact, Senator Frazier's made the pink page in my color scheme.
Is that bad?
That's bad.
Okay.
Let me talk about what we have in place now. We allow home rule cities, citizens in home rule cities, to do these referendi. We already have in place protection for private property owners, and that's called the court system, and a law you guys passed back in 1995, the Private Real Property Rights Preservation Act. That law allows people to go to court if more than 25% of the value of their property has been hurt. And we have court cases and a long history on those. We have some in Houston about where the city tried to restrict development around lakes. And in some of those cases, the courts have sided with the property owners. In other cases, they haven't. So we have an existing remedy for those who feel like citizen referendums go too far or do affect their property rights. But I feel like this bill, this proposed law, just goes way too far and takes away a fundamental right of citizens within the city. So we are opposed. It really prohibits a city from accepting a petition to put anything on a ballot that could even potentially impact real property rights. It's not clear. Again, it puts a lot of power and responsibility on the city attorney to determine what makes the grade and what doesn't. The correct way to do that is to see if the referendi passes, and if people are so upset with one, they go to court, and that's the proper venue. And so I'll end it there. And you know, a court really requires a regulatory takings analysis, fact-specific analysis that you really can't do at the city attorney level before something's even become been passed by the citizen. So that's the correct venue for this.
Okay. Any questions for Cyrus? Appreciate your testimony. Mark?
Fred. I don't
Go
think
ahead,
Mark's
Fred.
here.
Okay.
I'm Fred Lewis. I'm an attorney. I've worked a lot on petitions, drives, and providing legal advice to citizens in both the Houston area and in the Austin area. It's important to understand that this bill is a radical, grossly overwritten bill. It says basically that you cannot have an initiative or referendum on anything that would, quote, limit the use of real property for economic gain, all of which is undefined. So basically, what you're going to say is you're getting rid of the initiative and referendum process, because any lawyer knows you can turn almost anything into a property right if you try hard enough to describe it in that way. We've had initiative and referendum, not on the state level, but on the city level for 100 years. Now we've had this one outlier case in Denton that got a lot of people upset, and without thinking, without considering the unintended consequences of this, we're going to gut essentially all of the initiative and referendum process. So let me talk about the types of things that would limit the use of real property. Ordinances at the city level relating to adult entertainment, smoking, drinking, citizens who don't want to pay for a water treatment plant that would benefit somebody's property, arguably by providing more water. Anything that regulated music venues, their noise, because that would decrease their economic gain from being able to run their shows till 5 in the morning. Flood prevention. Money to or subsidies for private property. That would hurt somebody's economic gain. And these are actually examples. Austin had an initiative to prevent public subsidies of retail establishments. It was a $50 million tax giveaway over 10 years. Now it failed, but this wouldn't even be put on the ballot. Basically, what this doesn't understand is that property rights are not sacrosanct alone. Other people have real property rights, and their intention And that's what the system we have today does. It provides the city the power to regulate to provide regulations to protect real property and other people's real property for public safety, public health, and other public interest. And what this does is says the citizens will have no right, if they don't agree with their legislators, no matter how difficult the petition process is, to overturn their city council. This bill, just be real clear, this is not a little bill, this is not a little change, this is a radical change to government in Texas with little input and little thought.
All right, any questions for Fred? Senator Hall.
You did say you're an attorney?
Yes, I am.
How do you feel this would impact or is impacted by the Constitution that gives us the right to petition the government?
Well, we're going to find, if this is passed, we're going to find out if it's unconstitutional to take away the powers of the citizens in home rule cities to pass initiative and referendum. But it's not only unconstitutional, it's just incredibly poorly written and incredibly poorly thought out about the unintended consequences on all types of residents and businesses that are affected by other people who have businesses. I mean, businesses are often in conflict and property with each other. This has this sort of monochromatic view of property rights that's just naive, frankly.
Thank you.
Actually, there's some really good testimony. Thank you. That was one of the better ones I've heard. Thank you, panel.
Thank you.
Mark A. Miller, Libertarian Party of Texas, against the bill. Are you here, Mark?
Yes,
You want to talk?
That's just David Furlough. I was called, but I was.
Yeah, I'm getting to you.
Okay.
David Furlough, come on up.
Okay.
George Rodriguez, are you here? Okay, San Antonio Conservationists, does that sound right? Okay, he's against the bill. Roger Borglet? Borgel had to leave. He's registered against the bill. And so, David, you're up. What, name for the record, please.
David A. Furlough of Houston, Texas. I'm appearing here today because I've had experience putting issues on the ballot, not on oil and gas fracking issues. I believe those are adequately taken care of by House Bill 40's subsections B and C, which alleviate any need for this bill. I put on and led the legal effort to restrain the city of Houston and Federal District Judge Lynn Hughes by reversing him in the Fifth Circuit to put on the anti-red light camera election and to allow the people of the city of Houston to decide that matter. I oppose this bill because it's grossly overwritten, it's overbroad, it has unintended consequences, as the last speaker had to say. It violates Article 1, Section 27 of the Texas Constitution. Senator Hall is likely to be overruled in litigation that will be costly to the state of Texas. There have been 8 cases in which citizens have presented petitions to city secretaries to ban red light cameras or railroad extensions in the past 2 years. Those matters, if entrusted to a city secretary who is an employee of a city who works at the behest of the city council and the mayor, is likely to present to a person whose job is on the line to find reasons to deny the people's rights under Article 11, Section 5, a part of the Texas Constitution since 1911. The people who organize most of these matters, aside from these fracking type of matters, are Texans, often liberty-loving Republicans and libertarians, sometimes Democrats too, and they are the people, not out-of-state organizations, not out-of-state people who want to see their rights protected. This bill violates the constitutional rights of Texas citizens, and I urge you to look at it with respect to the litigation that's gone on. Companies like ATS fully presented and litigated their property rights issues, contending that referenda or charter amendments that restricted their rights violated their rights to due process, to property, constituted takings. This bill is unnecessary and I oppose it.
All right, any questions for David? Excellent testimony.
Just one quick one. Just in the past few years, we've had a referendum that has been rejected by the city councils for various reasons. I think Houston is not immune to that, where we had legitimate grievances with the people and they petitioned and it was rejected. Do you think this bill would make that even more difficult? for the citizens to bring an issue to the cities?
Absolutely, I do, because it vests discretionary authority in an undefined municipality, which could be decided, which could be either the mayor, the city council, the city attorney, the city secretary. That ambiguity has not been addressed or clarified in this bill. This is likely to lead to litigation, costly for cities, costly for the state of Texas, and costly for those civilian activists, those native-born Houstonians or people of other cities who want to have their constitutional rights protected, who want to object to tax hikes and ill-conceived systems that city councilmen and mayors affected by campaign contributions routinely impose on their citizens. That's why I believe that it violates the constitutional rights of Texas citizens. I don't care about people from out of state.
Thank you. That's a long yes. Thank you.
It's a yes, sir.
Thank you.
All right, any other questions? Thank you for your testimony.
Thank you.